Good morning, everyone. Thanks for taking the time and effort to be here today for our Panel B meeting. So I'd like to call the meeting to order at 9:11. Carrie, are you going to be taking roll?
Yes.
Could you
Mr.
call the roll?
Take it now? All right, Mr. Brooks? Ms. Campoverde?
Present.
Dr. Helzer?
Here.
Dr. Kraus?
Present.
Ms. Lawson? Dr. Mahmood? Absent. And Dr. Thorpe?
Here.
Great. We have a quorum.
All right. Thanks very much, Carrie. I appreciate your help. The next item on the agenda is the election of the panel chair and vice chair, and the floor will be open for nominations.
I'd like to nominate Dr. Thorpe for chair.
Is it the desire of the panel to take these separately? Probably that'd be the best, I suppose, right?
I'd like to second that.
Is there another nomination? Seeing none, all those in favor? Well, actually, Carrie, would you call the roll?
Mr. Brooks?
Yes.
Ms. Campoverde?
Yes.
Dr. Helzer?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Yes.
Dr. Thorpe?
Yes.
Motion carries.
Next would be a motion to elect the vice chair.
I'd like to nominate Ms. Campoverde for vice chair.
Second.
Is there any other nomination? Seeing none, Carrie, would you call the roll again?
I missed who seconded the.
That was Dr. Helzer.
Okay, perfect. And then I'll call the roll now. Mr. Brooks?
Yes.
Ms. Campoverde?
Yes.
Dr. Helzer?
Yes.
Dr. Kraus?
Yes.
Ms. Lawson?
Yes.
Dr. Thorpe?
Yes.
Motion carries.
Thanks, everyone. Thanks for your confidence in Ms. Campoverde and I. We are anxious to continue in this role and look forward to working with you for another year. So the next item on the agenda is the oral argument on the non-adopted proposed decision on Dr. Rahim Shafa. Judge Koch-Goodman, how would you like us to proceed here? Judge, are you available?
It looks as though maybe the judge fell off the WebEx.
Well, that's unfortunate.
Yes, indeed.
Yeah, I don't see her listed anymore. Let me.
I'm just looking at who we have listed currently, and I also don't see a DAG or counsel for respondent.
Yeah, I don't see
Am I
that either.
overlooking that?
Yeah. Got Mr. Shafa here, but. See if the judge is trying to get hold of me. Carrie, does the OAH provide you with a number to reach out to the judge or anything?
Not that I'm aware of. Let me go through my email messages and see if that was included anywhere.
Dr. Thorpe, are we on the record or?
Not yet. I mean, I don't believe we're on the record yet. We haven't started any formal proceeding at this point.
Thank you.
We would like to start a formal proceeding.
Sean? Okay, I'll make him up right now. He wasn't on my list, so thank you. We've got Greg Chambers. Greg, are you there?
I'm here, Sean.
Okay, so let us see if we can get a hold of the judge here before we go any further. Thank you very much, though.
Sean, there is not a contact number for the judge in the information that we receive when the judge is assigned.
She was the first one to join this morning, so I'm not sure what could have happened to her. Well, we're waiting. Mr. Shafa, are you with your legal counsel, or were they joining separately?
Yes, Your Honor.
Oh, I'm sorry. No, I'm just
I
IT
joined.
support here.
I had a problem with connection. Somehow I was able to connect this way. So I have a representative counsel, but I don't know. Maybe I came the wrong path to you.
No, you're in the right place. I have Miss Julie Lindstra as
Correct.
your attorney, but I do not see her in the list of attendees. Do you know if she is having any trouble connecting, or?
I just called him and left a message. Julie is the administrator for the office, and my attorney today is Attorney Lindsay
Johnson?
Johnson. Correct.
Okay. Miss Johnson, can you hear me? Miss Johnson, you're on a panelist role. You should be able to unmute yourself. See, you just disconnected audio. Let's see if you come back. Miss Johnson, I see your video's on, but it doesn't show you as connected to audio. Can you rejoin the audio or call in from a phone line? I see you mouthing yes. Thank you.
We appreciate the panel's patience while we try to bring all this together. It's sometimes a technical challenge to get everything done.
Carrie, could you try the main OAH line and see if we can get a hold of anyone who might be able to give us some contact
Absolutely, I'll
information
do
for
that right now.
Judge Coach Goodman? Coach Goodman.
Hi, Sean. I'm actually trying that right now myself. This is
Thank
Erica.
you. Thank you, Erica. Ms. Johnson, can you hear me now? Up above in the audio and video settings, there's a drop down and it'll say switch audio. If it's not detecting audio on your computer, there's some call-in options there that you can use to call in from like your desk phone. It'll give you the number to call and the meeting number and your attendee ID to type in there. Okay, Ms. Johnson, I see you've joined by phone now, it looks like. So there's still a mute control on your computer. If you can hit the unmute button on your computer, it should now open up your line.
Okay, is that better?
There we go. And yeah, feel free to put it on speakerphone and that should pick up, just fine in your office. Thank you.
Okay, I apologize. I could hear. I'm not sure what was happening on this end or on either end.
No problem. You can still use the mute control on your computer there to mute and unmute yourself during the course. We're still waiting to try to track down what may have happened to Judge Koch Goodman here, but we have at least the attorney and subject and DAG present now, Dr. Thorpe. So please bear with us a few more minutes while we try to reach out to the judge.
Thank you, Sean. Thanks for your patience, everyone. We'll try to get underway as quickly as we can get the judge back online. She was here early, and I'm not quite sure what happened. I'm sure it wasn't, it must have been some technical problem because she was clearly here early to be available.
Hi, Sean. I got a hold of somebody at OAH who's communicating with her right now.
I just got an email from her too. It sounds like her computer has locked up or something. So. She's trying to reconnect here, so at least we know that she's still online and stuff. So hopefully we hear something soon. Judge Koch Goodman, you there?
Yes, I am here. Thank you.
Thank you, Judge. Okay.
Good morning, Judge. Thanks for your persistence in.
I feel like we've all learned new language this past year or so. It's called technology, and I'm kicking and screaming going in. So.
Well, we appreciate your persistence in coming back to it. Judge, we want to turn the time over to you. How would you like to proceed?
All right. So if I just understood you correctly, you're ready for us to do the oral argument in this case?
That is correct.
Okay, very good. So Ms. Menares, and I see you there. I'd like to go on the record this morning, please. Okay, very good. We are here in the time and date, and we are by video conference for oral argument on the matter of the Medical Board of California versus Rahim Shafa. It is R-A-H-I-M, and last name is S-H-A-F-A-M-D. Now, I am attempting to make sure I can see all participants. Aha, there you are. I've just gotten a wave. On behalf of Mr. Shafa, for the record, please, an appearance.
Good morning, Your Honor, and members of the board. Lindsay Johnson, on behalf of Respondent Rahim Shafa, who is present via WebEx.
All right, very good. Thank you so much, Ms. Johnson. And then do we also have Ms. Wagner, who will be appearing on behalf of the medical board?
No, it's myself, Your Honor, Greg Chambers. I'm with Attorney General's office.
All right, very good. Thank you so much, Mr. Chambers. I appreciate your notification of appearance. Let me do a couple of things here. My name is Erin Koch-Goodman, and I am the administrative law judge that has been asked to officiate over or administer over this proceedings this morning. The case number that I have been given from the Office of Administrative Hearings is 2021-100-725. But I do want to note for the record that the underlying matter that was not adopted by the panel was actually OAH number 2021-010-334. So I want to make sure that all of these cases are connected if somehow they are divergent in any way. And the medical board case number is 800-2020-070-360. And again, we are here for an oral argument on the non-adopted decision in the underlying matter. There has been a request for oral argument, and we will proceed according to the California Code of Regulations, Title 16, Section 1364.30. And I will just give you a brief roadmap. That means that we'll have opening argument from the Respondents' Counsel, 15 minutes response argument from the complainant. In this case, Mr. Chambers will be speaking, and that is 15 minutes as well. For those of you who are speaking, I'm happy to set my timer, and I'll give you a 5-minute warning, and then I'll proceed from there. And then we'll have closing argument. Well, in between, we may have questions. And if we do, I will be swearing Dr. Shafa in if there are questions for him, and taking any questions from the board members to counsel as well. And then we will have closing argument from the respondent with a 5-minute time limit, and a closing argument from the complainant with a 5-minute time limit. And then the board or panel B, pardon me, will adjourn into closed session to discuss the matter. Ms. Johnson, any questions or any clarification for the record before we get started?
No, Your Honor.
All right, very good. Mr. Chambers, anything for the board itself?
No, Your Honor.
All right, very good. What I do want to do, I think, so that we have a complete record, is identify the board members so that we aren't necessarily in person, but by video. And I want to make sure that I have all of the board members. Dr. Thorpe, should we start with you since you're the chair, or did I understand there might have been a new election of some sort?
Actually, the election confirmed the current slate of officers.
Okay.
So we're still good.
Okay, very good.
So you're sure you can start with me?
All right, very good. If you could just state your name, please.
Richard Thorpe, MD.
Very good. And you are the chair of panel B. And before I left, I don't know if I saw Miss Campoverde.
Yes, I'm here, Your Honor.
All right, very good. And if you could state your first and last name for the record, please.
Alejandra Campoverde.
Okay, very good. And you're the vice chair of panel B, is that right?
Yes.
Okay, very good. And then I'm not sure if you all like to go in different order. I have the document open and in front of me with the list of panel members' names. So perhaps I can just ask, is Ryan Brooks here for the meeting?
I'm present, Your Honor.
Okay, very good. And Dr. Helzer, are you present?
Yes, Your Honor.
All right, very good. And Mr. Helzer, Dr. Helzer, pardon me, it is James Helzer, is that correct?
That's correct, Your Honor.
All right, very good. And then Dr. Kraus, do I have you?
Yes, Your Honor.
All right, very good. And it's Howard Kraus, MD, is that correct?
Yes.
All right, very good. And Miss Lawson, do I have you?
Yes, good morning, Christina Lawson, Your Honor.
Very good, thank you. And just because everybody else gets their initials after their name, we'll add the JD after yours.
Fair enough.
And then finally, Dr. Mahmood, are you present?
He is not present this morning, Your
Is
Honor.
not present this morning. All right, very good. And is there anyone else I've missed from the panel? All right, hearing nothing. In that case, then let me set my timer here and we can get started. All right. In that case, Ms. Johnson, the floor is yours.
Thank you. Good morning once again. Licensed in 1992, Dr. Shafa has spent 29 years practicing with a valid and active license. He has no administrative discipline and no criminal convictions. We are here today because the board has sought a suspension order of Dr. Shafa's license based on Business and Profession Code Section 2310 on the basis of an alleged out-of-state suspension in Dr. Shafa's Massachusetts license, which the board therefore is trying to use as a suspension for Dr. Shafa's California license under, as mentioned, Business and Profession Code Section 2310. However, as properly noted by Administrative Law Judge Juliette Cox in her decision of this order, the board has not, because it cannot, meet the predicate for discipline required by the statute. As a result, the board cannot seek the suspension of Dr. Shafa's California license under the mechanism that it has chosen to try to operate under.
I'm sorry, repeat that?
Under the mechanism that it has chosen to operate under. The reason for that is that the board has not been able to meet the required elements of the statute. As a predicate to seeking discipline under Business and Profession Code Section 2310, the board must show that first, the provider operates primarily in a different state. Second, that another state or jurisdiction has suspended or outright revoked the provider's license to practice medicine in that jurisdiction. And third, that suspension or outright revocation has been reported to the National Practitioner Data Bank. Upon review of this matter, both on the face of the documents and based on the clear, plain language of the statute, we see that the first two required elements are not met. First, Dr. Shafa's license in another jurisdiction has not been suspended or outright revoked. And second, no such suspension or outright revocation has been reported to the National Practitioner Data Bank. Turning to the first issue, whether or not Dr. Shafa's license in any other jurisdiction has been suspended, we see that the answer clearly is no. The board has moved for a suspension order based on a voluntary agreement entered into between Dr. Shafa and the Massachusetts Medical Board, where Dr. Shafa agreed to temporarily stop the practice of medicine through that agreement in Massachusetts. This voluntary agreement, however, is not akin to a suspension and certainly not akin to an outright revocation. How do we know that? We know that from a couple of key issues. First, the document itself notes it to be a voluntary agreement, not a suspension and not a revocation. Second, the document notes that it is not disciplinary. It is a non-disciplinary action, which by both common knowledge and common interpretation, suspension and revocation would be a disciplinary action. But perhaps most tellingly, we see in term 8 of the document that should the voluntary agreement be violated, the next step that Massachusetts could seek would be the suspension of Dr. Shafa's license in Massachusetts. If Massachusetts considered the voluntary agreement to be a suspension order, there would be no reason for it to expressly state how a suspension order could then be sought as a subsequent action. As a result, it is clear that Massachusetts does not view this as a suspension order. It does not view it as an outright revocation order, and it is not California's job, nor is it California's right, to step in and tell another state what that other state's disciplinary action actually is when that other state has clearly defined it in the document itself. Second, we look to the idea of what has been advanced in complainant's written argument as to whether or not we can now move aside from the plain language of the statute, interpret it differently to include voluntary agreements, assuming we all agree that the document speaks for itself and therefore is not a suspension order or a revocation order. Statute and case law are extraordinarily clear on this issue. When the legislature has put out a statute, then we are to follow the plain language of that statute. We are not allowed to read in new qualifying terms, nor are we allowed to interpret the statute different from the plain language of the statute. And the plain language of the statute is very clear. There must be a suspension or an outright revocation order. A voluntary agreement is not contemplated in the statute, nor should a voluntary agreement be contemplated in the statute. How do we know that? Well, we know that one from the statute itself, but two from case law. When reviewing matters to determine how we should look at legislative directives, how we should look at statutes to see whether or not they can be interpreted differently from what the statute itself expressly states, courts have told us over and over again that the answer is no. Turning first to Diamond Multimedia Systems, Inc. versus Superior Court, a 1999 case found at 19 Cal 4th, 1036, pin site at 1047. We are told that if there is no ambiguity in the language of a statute, then the court must presume that the legislature meant what it said, and the plain language meaning of the statute therefore governs. We then turn to another case, which would probably be easiest if we spell for the record. KHAJAVI versus Feather Anesthesia Medical Group. 2000 case found at 84 Calat 4th, 32 with the qualifying pin site at page 48, which instructs us once again that when construing statutory provisions, a reviewing court may not insert qualifying provisions that do not appear in the statute's language. And that is expressly what complainant in the written argument is attempting to do. It is attempting to insert voluntary agreements, or what it deems limitation agreements, into Business and Profession Code Section 2310. But as the court found in Feather River Anesthesia Medical Group and its progeny, that is not allowed. The legislature was obviously aware when it drafted 2310 that there were more options out there than just suspension and revocation orders. How do we know that? Well, at a similar time period, legislature drafted Section 2305 of the Business and Profession Code. And in that section, which is not at issue today and has not been raised as a code section which one can seek discipline for today, we see that the legislature included not only suspension and not only revocation, but it also included other limiting actions or other limiting events that could seek further license discipline. Therefore, it is abundantly clear that the time that 2310 was drafted, the legislature was well aware that there might be agreements outside of suspension and revocation order that might impact the practice of a provider's practice. And yet, despite being well aware of that fact, the legislature still drafted 2310 to include the required elements of suspension or revocation as the only two options in which one in California can therefore seek suspension of the license. By expressly choosing to not include any other agreements beyond suspension or revocation, and by looking at the case law which tells us we cannot insert new qualifying language and we must let the plain language of the statute control, we can see that 2310, as a predicate to suspension discipline in California, requires either suspension of an out-of-state license or revocation of an out-of-state license. The voluntary agreement entered into by Dr. Shafa in Massachusetts is neither of these. We see it by the document itself, and we see it by the fact that Massachusetts notes that suspension would be a different step that it would take separate from this voluntary agreement. And therefore, there is no out-of-state suspension order, there is no out-of-state revocation order, and the first required element of Business and Profession Code Section 2310 is not met. Because that element is not met, we need not look at the National Practitioner Data Bank entry element. But out of an abundance of caution, we certainly can, because that entry once again supports Dr. Shafa and the lifting of the suspension order in California. First, it should be noted that the entry, assuming it is in fact an entry, of a National Practitioner Data Bank issue from Massachusetts was entered as administrative hearsay in the underlined administrative matter. And that is the record that we are held to today. There was no direct evidence entered demonstrating a confirmed copy of any entry to the National Practitioner Data Bank. But turning to the exhibit that was entered, if we look at that and we take the assumption that it is in fact an entry from the National Practitioner Data Bank, it is clear that that entry also does not note Massachusetts as a suspension or revocation order. Instead, the entry that was entered as the underlying administrative proceeding notes that there was a non-disciplinary action taken by Massachusetts. Once again, suspension or revocation, because it infringes on a vested interest, is a disciplinary action. And therefore, the entry on the National Practitioner Data Bank, assuming we take it as the entry that is in fact one that can be considered, setting aside the administrative hearsay issue raised by statute and by case law under Berg versus Davey, we see that once again, the National Practitioner Data Bank does not consider this to be a disciplinary action. And where does the National Practitioner Data Bank receive its information? It receives it from the entity that has created it. This once again reinforces the idea that Massachusetts did not consider this to be a disciplinary action, something it noted in the voluntary agreement itself, and something it apparently has reiterated to the National Practitioner Data Bank, assuming in fact that the entry is valid. Because the board is unable to meet the statutory requirements of Business and Profession Code 2310, the suspension cannot stand. It should not stand under the interest of justice, because quite frankly, justice requires that the entity that is taking the action be able to actually prove that it has the authority to take that action, which the board has been unable to do at this point. In written argument, complainant raised an interesting concept. Curious, because it argues that to rescind the suspension would be a violation and would not be in the interest of justice. First, complying with case law and complying with statute is in the interest of justice. It shows that we follow the judicial system and we follow the laws that have been outlined for us. But second, there has been no evidence to demonstrate that Dr. Shafa is a danger to the public, such that California citizens need to be protected from him or protected from his continued licensure. As mentioned at the beginning, he has no administrative discipline, he has no criminal convictions, and he has, to his knowledge, no patient complaints. In fact, the evidence was overwhelming that Dr. Shafa is supported by not only the medical community, but also by his patients themselves. While we need not look at the interest of justice to determine whether or not we should protect the public from this practitioner, because ultimately we start and can end at the question of, does the authority exist to suspend him? And the answer, of course, is no, not under the statute advanced by the board. But even if we were to look at it a step further and say, does the public need to be protected from Dr. Shafa, and therefore we should keep a suspension order in place that is not established by law and is not allowed by statute? The answer, once again, is no. The argument submitted by complainant advances this idea of public protection, interest of justice, the idea that Business and Profession Code Section 2305 discusses more than just suspension and outright revocation. these are all basically red herrings. They sidestep the only issue that the board is here to contemplate, that the board has brought forth a cause of action under 2310, and can the board sustain that cause of action under 2310? When looking at the red herrings, there are obviously other options. If the board truly wants to operate under Business and Profession Code 2305, well, the board has already brought an accusation under that code section. That's not what we're here for today. In fact, at the underlying administrative hearing in this matter, the hearing that we are actually contemplating, respondent was willing to move forward at that time and address both the suspension order and the accusation, which raised the issue of Business and Professions Code Section 2305. It was complainant who expressly noted at the beginning of the record that it did not want to proceed at that time with the accusation or a contemplation of Business and Profession Code Section 2305. To bring it up now as an attempt to argue why it should instead be allowed to reinterpret Business and Profession Code Section 2310 is not only inappropriate and not only contrary to previous arguments, but it is not the way that the interest of justice is protected.
Ms. Johnson, that's your 15 minutes.
Then that is a very good ending point. Thank
Very
you.
good. Thank you. Dr. Thorpe, I'll ask you, I don't know if you want to ask questions of Ms. Johnson now, or if you'd like to hear openings from both sides.
I would like to hear openings from both sides before we ask questions.
Wonderful. Very good. Thank you. Mr. Chambers, I'll give you the floor. Again, I'll give you 5-minute, 3-minute, and 1-minute warnings. All right?
Thank you.
All right. Take care.
Well, obviously, complainant disagrees with respondent. Respondent signed an agreement with the state of Massachusetts licensing authority that precludes him from practicing medicine, not just in Massachusetts, but in any state in the union. An agreement that he cannot break unilaterally. This is an agreement that he signed, as he stated in his testimony, quote, just a few days, close quote, after his arrest. You can find that at transcript page 71, line 22. Respondent now asks the board to permit him to practice medicine in California so that he can go back to Massachusetts and ask them to let him practice in California again, even though he can't practice in Massachusetts under this agreement with that state agency. So in other words, he's telling you that Massachusetts determines his fate to practice medicine in California, not you. Now, with regard to the technical issues regarding Business and Profession Code Section 2310, subsection A, that were just raised. The requirement that the respondent's Massachusetts, well, 2310A requires A, that respondent's Massachusetts license be suspended and that the information be sent to the National Practitioners Data Bank. The agreement was entered into by respondent, quote, during the pendency of an investigation, but it is reported to the data banks, close quote. You can find that at Exhibit 8, Bates page 38, and that is from the Massachusetts state agency that provided us all the records. You note that they did not say a single data bank that this information was provided to, but it was provided to, quote, the data banks, close quote, all of them, which would include the National Practitioners Data Bank. And as for the agreement, respondent could not have voluntarily chosen not to practice while this criminal investigation was ongoing, but the state of Massachusetts clearly wanted something that had some teeth in it in light of the indictment. So the agreement precludes him from practicing medicine, not just in Massachusetts, but from any state in the union. Let's be very clear. Respondent signed an agreement that is draconian. Respondent cannot practice medicine anywhere in the United States, and only the state of Massachusetts can end this agreement. This precludes respondent from practicing anywhere in the United States, and it is very much a penalty. Respondent very much noted that this is a penalty when he was questioned by his own counsel, which you can find at transcript page 68, lines 16 through 18. And he noted his lack of income because of the terms of this agreement. This was a penalty. Respondent cannot unilaterally pull the plug on this period of non-practice. Massachusetts determines how long the agreement will last. You can find that in paragraph 4, Exhibit 8, base page A38. Respondent may not want to call this a suspension, but there is no other term for this. A suspension is a suspension, regardless of whether he stipulates to that action. In this case, he did stipulate to it. Why? Because it was just a few days after his arrest. He really didn't have a choice. Respondent does not now get to redefine the action because the cause and the effect, they're still the same. This isn't a voluntary, unplanned vacation. It's not a practice retirement. It is an indefinite suspension of medical practice, and that indefinite suspension is nationwide, and it lasts as long as Massachusetts wants. There was a discussion as to whether this was discipline. We've already addressed that. It was discipline. He is not incurring any income at this point in time. Nationwide. So we know the respondent's license was suspended by another state, and that agency reported the matter to the requisite databanks as required by Business and Profession Code Section 2310, subsection 8. The board complied with the code, and the suspension should remain in place. Thank you for your time.
Thank you very much. All right, it is at this time that I will offer the panel members if they have any questions. If we could start with questions for Ms. Johnson and then move to Mr. Chambers. So let's start with questions for the respondent's case. Dr. Thorpe, do you have any questions?
So Ms. Johnson, how do you respond to that that question Mr. Chambers raised? Though it was not technically charged as discipline in the Massachusetts action, it effectively was discipline in that he has not been able to practice. That does seem to be a significant issue.
Well, first, there are different levels of discipline, as one knows. And in Section 2310 of the Business and Profession Code, it does not state that California may suspend a license because there has been a blanket discipline, assuming we accept its discipline, which obviously we do not. It says it must be a suspension or a revocation. Those are the only two options outlined, and they're clear in the statute. The Massachusetts agreement notes that the next step that it could take if the voluntary agreement is violated would be a suspension. So Massachusetts obviously does not consider this to be a suspension, and it obviously does not consider it to be a revocation. If it is neither of those, then 2310 in fact is not met under any circumstances. Turning back to the idea of, is this discipline? Well, one, like I said, the statute does not contemplate that the board can take action on any form of discipline. For example, if Massachusetts or any state placed a provider on probation or issued a reprimand or issued a citation, under California law, those are all different levels of discipline. But the suspension section of 2310 does not kick in under those forms of discipline. So the idea that we get to suspend a practitioner in California if another state takes any form of discipline is in fact not true and not supported by the statute. Equally important, non-practice and having a license suspended are not the same thing. The argument that it appears was just made is this idea that because he cannot practice in another state based on his agreement with Massachusetts, he therefore should lose the license in another state. We know that a license carries more weight than just the ability to practice in that state. There are positions that require one to be licensed even if they end up not doing clinical work as a part of that position. And so as a result, this idea that any form of discipline in another state therefore triggers suspension in California, I mean, frankly, it's just not supported by statute, it's not supported by case law, And we can't start to read in these hypothetical ideas because at that point we find a violation of the law.
Thank you.
All right, I'm not sure if we have lost one of our panel members. I am no longer seeing Miss Campbell-Verdick.
She did get knocked off. She'll be rejoining momentarily.
Okay, I'll come back to her in that case. Thank you. Mr. Brooks, any questions?
I do, Your Honor. Thank you very much. So, Ms. Johnson, question for you. So, if we allow the doctor to practice in California,
I'm sorry, repeat that, please.
if we allow this doctor to practice in California, he will have violated his agreement. Is that correct? With the state of Massachusetts.
If we allow him to practice, now it should be made very clear that Dr. Shafa has a California license. And so it's not a question of are we allowing him to practice, it's a question of are we taking away his vested interest, which is his license, and can we actually do that? Additionally, like I just mentioned, practice and a license are not the same thing. So by allowing Dr. Shafa to keep his license, a license that he already has, we are not saying that he is therefore going to practice. We are simply saying that we are not suspending a vested interest of that license. But that was a long way, I apologize, of answering your question. I just want to be very clear.
No, I appreciate the response. So then my second question then is, if we allow him a license in the state of California gives him the right to practice, is that correct?
Well, and this goes back to, I want to be very clear, the board is not allowing him a license. Dr. Shafa already has a license in California. The board is trying to determine whether or not it's going to discipline his license. And so California, if it is continuing to continue the valid license in California, it's not necessarily telling Dr. Shafa, go practice. It is simply saying we have not taken away a license that we have already provided you, and we are statutorily required to impose due process on to take it away from you. Just because one has a license does not mean that they are practicing. And as mentioned, there are numerous positions out there, research, academia, administrative positions, that the entity would require a license, but does not actually serve or does not actually require the clinical practice of medicine. Therefore, the California license holds numerous benefits. Not only is it something he already has, and therefore we have to proceed through due process to infringe on, but additionally, just because he continues to have it does not mean that California is somehow stepping on Massachusetts' toes or is encouraging or inciting the violation of a Massachusetts order.
If Dr. Shafa decides to practice, and practice doesn't necessarily mean in the hospital setting. Practice could be in multiple settings.
I'm sorry, repeat that, please.
So I said, if Dr. Shafa decides to practice does not necessarily mean in a hospital setting, correct? And so if he's giving advice, he is actually practicing as a licensed doctor in California. That being the case, would he have to notify the state of Massachusetts?
Absolutely. I mean, Massachusetts is in control of Massachusetts' agreement. And so Massachusetts should decide and should certainly be aware, and like I said, should decide when that agreement is violated. And then it would be in Massachusetts' jurisdiction to decide what, if anything, it would do in response to that.
But so if we allow him to practice in the state of California, he would be in direct violations of his agreement in Massachusetts. Is that correct?
Not that the board would be in violation. Dr. Shafa would have a violation of his agreement. But like I said, this goes back to the idea of allow practice. I want to make sure that we're very clear on this issue. Just by letting a person hold a license in California, we are not inciting the practice of medicine. And I have a little bit of a concern that there's a concept that the license that one holds in the state of California can just be given and then just be taken. There's a due process requirement once the license is originally granted in the first place. Dr. Shafa is not seeking a license in California. If he were, that would be a violation of the voluntary agreement. I certainly agree with that. Dr. Shafa has a license in California. He has had that license in California since 1992. And what this board is determining is whether or not they have the statutory authority, the due process that is required to be performed when somebody holds a license to actually temporarily stop the use of that license. So the idea and the question here is not, should we allow Dr. Shafa to continue to practice and therefore possibly run afoul of Massachusetts? The question here is, now that Dr. Shafa has a license in California, has long held a license in California, do we have the statutory authority to take that license away from him, even temporarily? And the answer to that is not only no, but also this idea that we should do so in order to make sure that Massachusetts' order is properly held up to. That is not something that statute provides to California, and it's not something Massachusetts has asked California to do. Massachusetts has not asked California to enforce its own order, which makes sense. States want to enforce their own orders. The way California would want to enforce an order that it drafted, Massachusetts should and does have the right to do so on its side as well.
Thank you.
All right. Thank you. Ms. Campbell-Verdick, we're glad to see you back. Do you have any questions for Ms. Johnson?
Thank you. I apologize. I was booted out, but I do have a question. If this has already been covered while I was gone, I apologize. But, you know, as you mentioned, our duty is to protect patients here in California. And for me, there's a piece of the puzzle that is missing that I'd like to understand better. And that's that these criminal charges arose from something related to his medical practice. What were those criminal charges related to? That would help us understand better our duty to Californians.
I certainly understand the desire to know. I recognize that absolutely. I will say, though, for a couple of reasons, it is concerning if the criminal matter or the criminal allegations are actually part of the contemplation of what California is going to do. Under Government Code Section 11503, it is very clear that the board is only allowed to consider the allegations that have been raised in the initial charging document. And in this case, it's the Business and Profession Code Section 2310 suspension order. We are not allowed to look outside of the initial charging document to contemplate new potential reasons that one might be disciplined. And so if the criminal charges are becoming a contemplation for what to do about this order, that would actually be in violation of the government code. Second, the underlying issue is these are criminal allegations. They have not germaned into an actual conviction. And under Naidu versus Superior Court in the state of California, we can see that license discipline cannot be used as a tool for pre-conviction discipline. Essentially, when someone's out on bail, we can't suspend the license because we're worried about something down the line that may or may not happen. It's very clear that Dr. Shafa does not have any criminal convictions, and so I would be concerned that if the board were to try to dig deeper into the criminal complaint that has been levied and then rest its decision based on that, there would be a violation of the government code, there would be a violation of case law. And that's the reason you can see in the transcript that information was attempted to be entered regarding the criminal case, and the administrative law judge would not enter it for relevancy reasons. And we would continue to raise that same concern here today.
Ms. Lindsay, what is the citation that you just gave as it's relative to the pre-conviction discipline?
It is Naidu versus Superior Court, and I apologize. Let me actually pull it up for you. I did not intend on raising it today, so.
If you could spell that first name or that last name for us of the caption and then give us the citation, I would appreciate it.
Of course. It is Naidu, and then it is a 2018 case. It's found at 20 Cal App 5th, 300. It takes guidance from Gray, Gray, versus Superior Court, a 2005 case, which is found at 125 Cal App 4th, 629. It should be noted that Naidu was contemplating a CSLB license, so a California state or contractor state licensing board, but Gray was actually a physician and it was a medical board of California case.
Thank you very much. Ms. Campbell-Verdick, I apologize for that interruption. Do you have any other questions for Ms. Johnson?
Yes, well, as the non-lawyer and the non-doctor here in the group, for me, because these criminal charges were tied to his medical practice, it seems relevant for us to understand when we're trying to get an idea of everything that's going on and so on. And so I understand what you're saying, but it seems very relevant in this case.
And I understand that as well. I'm not trying to be contrary. The problem is it's hard for me to take the lawyer hat off, and because the law is very clear that it's not relevant and it can't be contemplated, I worry that if we start to go down a discussion of the underlying facts, you can't necessarily unring that bell the way that case law and statute tells us to, that you can't consider the underlying criminal matter. And because you can't consider the underlying criminal matter, that's the reason why it would be deemed irrelevant. And also there's a concern, like I said, that if we start to discuss it, one, we are starting to agree to a violation of statute and a violation of case law. And two, it then gives the board not only the tools, but like I mentioned, if you can't unring a bell, then in the back of the mind, it gives the board these contemplation. The most that I'd be willing to say about the criminal matter in this is that it was not a quality of patient care issue. So if that is the concern, that there are criminal charges stemming from that he's harmed somebody or that there's a quality of care issue, that is not the case. There has been a quality of care issue raised against Dr. Shafa. In fact, as mentioned and is included in the evidence of the administrative hearing, his patients and his colleagues are united that he is a benefit to the profession, and that has not been raised as an issue in either the administrative realm or the criminal realm.
All right, Ms. Campbell-Verdick, any other questions?
No, thank you, Your Honor.
All right, Dr. Helzer, any questions for Ms. Johnson?
Thank you, Your Honor. Ms. Johnson, if Dr. Shafa has agreed not to practice in any state and can't exit the agreement voluntarily, how does that not have the same effect as a license suspension, even with the clause stating it's non-disciplinary?
And I'm sorry, the very last part you cut out, and the caption does not appear to be accurate. Can you repeat just the end of your question?
Sure. Even though the agreement says the agreement is not disciplinary, how is this not the same as a suspension?
Well, a couple of ways. First, the agreement notes that if the agreement is violated, then the next step Massachusetts would take or could take would be a suspension. So clearly Massachusetts does not consider this to be a suspension, because if it did, it would not need to note that it could then take a suspension. It already has a suspension. And second, this goes back to the concept of, is disciplinary the same as suspension and revocation? And the answer clearly is no. There are several different forms of which discipline can take place. There are voluntary agreements, perhaps, but there are certainly probation, letters of reprimand, citation. This board itself has used several different avenues of disciplinary action that are not a suspension and that are not a revocation. And so while Dr. Shafa has entered into a voluntary agreement that limits his practice, we certainly agree with that. It does not mean it is a suspension order, nor does it mean that it's a revocation order. Something else to keep in mind, and it's something that was raised during opening by Mr. Chambers, is that he didn't have Dr. Shafa, being the he didn't have a choice but to sign this agreement. We have absolutely no evidence of that. We have no evidence that Massachusetts has brought forth an administrative action and this voluntary agreement is some sort of settlement to resolve that. Instead, it's very clear this is a voluntary agreement entered at the beginning between Dr. Shafa and the Massachusetts Medical Board. It's not a suspension and it's not a revocation, and those are the only two things statute contemplates. I know it may seem like I'm making a technical legal argument, and perhaps I am. I'm a lawyer. I'm certainly willing to acknowledge that I can see my own shortcomings. But that technical legal argument is important. The statute does not say that the California Medical Board can suspend a license if another state takes any disciplinary action. Instead, the statute is very clear and very limiting. California can only seek the action it's seeking under this particular statute if there is a suspension order or an outright revocation order. If California wanted to seek discipline for any disciplinary matter, California would operate under a different business and profession code section. 2305. And that's actually the Business and Profession Code section that this board has issued the accusation on against Dr. Shafa. And so if it wants to contemplate a global disciplinary concept, it will do so under that accusation. That's also when getting back to the prior question by the prior board member, when the idea of the protection of the public is raised under that statute. However, the board chose, it was its decision to not proceed with the accusation at the time of the suspension hearing. So because of that board decision, it's very important that we continue to keep the matter separate today and look at the only thing we're contemplating today, which is section 2310, which expressly notes suspension or revocation as the only two options in which the board can proceed.
Thank you. I don't have any other questions.
Very good. Dr. Kraus, any questions for Ms. Johnson?
Yes, thank you, Your Honor. Ms. Johnson, it would help me to have a definition. And I've heard that Dr. Shafa is not intending to provide direct patient care, but wishes to be employed in supervision of clinical trials or other activities, not including direct patient care. But it would help me to have a definition of the practice of medicine, which to my knowledge includes those things that are outside of direct patient care as well. Could you define the practice of medicine for me?
Well, the practice of medicine is defined in several different areas. So everyone obviously has their own personal definition. Statute and case law have considered it a little bit of a gray concept, so I don't want to be misleading to this board at all. It's important to me that it's just the legal arguments and the facts are out there. Practice of medicine typically, though, as a general global concept, where most statute and case law are united, is the idea that it is one who is treating, who is diagnosing, or who is performing. And typically the performing requires either the mental performance or often it is an impact on the body. So under the skin is a term that's often thrown around. Now, Dr. Shafa, of course, provides mental health services, so that definition is a little gray. But diagnosing, treating, and providing that care is typically kind of the global concept of the practice of medicine. And so I think without going into the nitty gritty or starting to do conflicting cases or conflicting statute, that would probably be the most go-to definition that can be provided. Although I once again want to be very clear, we're not asking whether or not this board should allow Dr. Shafa to continue practicing medicine. We are asking whether or not this board has the authority to suspend Dr. Shafa's medical license, which is a license he already has under the statute in which it has proceeded to operate in under this matter.
Thank you.
All right. Ms. Lawson, any questions?
I don't have any additional questions. Thank you.
All right, very good. I think we've covered everyone. I will go back through the group just to ask if you have questions for Mr. Campbell, or Mr. Chambers, pardon me. And so I'll return to you, Dr. Thorpe. Any questions for Mr. Chambers?
Yes, thank you, Judge. I did have a question, Mr. Chambers, and that is, it does seem that to me that there is a legitimate argument that the respondent's attorney has made that you are now number one invoking 2305, and then also that somehow we're changing the definition of what the statute requires in 2310. Can you address that?
Sure. I don't think we need to address 2305 because I think 2310 has been proven at hearing. So we're not even going to 2305. 2305 is part of the out-of-state accusation that's based upon the criminal matter in Massachusetts. The 2310 subsection A, we're not changing that at all. There are two elements to that. The first is that there's a suspension, and we've shown that. Second, that it was presented to the National Practitioners Data Bank, and we've presented that as well through the evidence that I presented to you previously in the opening argument. So we don't have an issue with regard to 2305 here because that's not before this panel. It's 2310A, And we believe we presented sufficient evidence at the hearing and presented it today and shown you the transcript and the exhibits that are necessary to make the facts meet the elements.
Thank you.
Ms. Campbell-Verdick, any questions for Mr. Chambers?
I don't have a question. Thank you.
All right, Mr. Brooks?
No other questions. Thank you.
All right, very good. Dr. Helzer?
No questions. Thank you, Your Honor.
All right, Dr. Kraus?
Yes, thank you, Your Honor. Mr. Chambers, I have a similar question, and that is my understanding of Ms. Johnson's response is that the practice of medicine relates to the evaluation and management of a patient. And I'm wondering if you understand the definition of the practice of medicine to be more inclusive than that, or would adhere to the similar definition?
I apologize, Dr. Kraus, and I'm not going to be able to give you a straightforward answer to that because we deal with the definitions presented in the government code and in the and in case law. So I'm really uncomfortable defining the practice of medicine outside of what is defined by statute and by case law.
Thank you.
But if I could, that's sufficient. I apologize, Dr. Kraus.
I appreciate the response. Thank you.
Ms. Lawson? Oh, I just lost you.
No questions.
Okay. All right, fair enough. In that case, we will turn now to closing arguments on behalf of each side. Each side will have 5 minutes, and we'll begin with Ms. Johnson on behalf of Dr. Shafa. Both for you, Ms. Johnson, and for Mr. Chambers, I'll give you the 3 minutes, the 1 minute, and then I'll say we're all done. And so let me quickly set my timer to 5 minutes. And the floor is yours, Ms. Johnson.
Thank you. Well, at this point, the panel has heard from me at length, so certainly I do not want to belabor any points. I will first note, though, in response to questions just now, Mr. Chambers noted that they, presuming complainant, has shown that this is a suspension and therefore met the element of 2310. Absent simply stating that this is a suspension, however, we have not actually seen any evidence of that. As noted, Massachusetts clearly does not consider it to be a suspension, or it would not have singled suspension out as a second possible additional element it could take or action that it could take. It is not the place of this board, it's not the place of me either, to tell Massachusetts that its agreement is something different from what Massachusetts has expressly stated that its agreement is. Therefore, we have not seen any evidence that this is a suspension or that this is a revocation. The only document that we have seen that Massachusetts has provided expressly notes that it is not a suspension. And if it is not a suspension, then this board, under Section 2310, cannot issue a reciprocal suspension. There has been a discussion, and it's an understandable discussion, as to whether or not California would be allowing Dr. Shafa to violate the Massachusetts agreement if California did not suspend his license here. I want to be very clear, though, and maybe this goes against everyone's natural instincts, but that is not the law in this matter. That is not what this panel should be contemplating. It's not what this panel can contemplate. Massachusetts holds the ability to determine whether or not Dr. Shafa has violated his agreement, something that, to be clear, he has not done yet. And it's Massachusetts' decision on whether or not it wants to proceed with that. A license is a vested interest that, once it is provided to a licensee, cannot be stripped unilaterally without due process. And due process requires that in order to strip that license, the board must demonstrate under statute that it has the authority to do so. There is no statute that has been raised that provides California with the ability to take the license based on the concept that it thinks by doing so it is helping another state for that state to possibly enforce its order. That is not an authority that is provided to anybody. Instead, what we must look at is, does California have the authority to take the license that has already been provided to Dr. Shafa through this isolated mechanism that it has chosen. Whether or not California has the authority to suspend his license or revoke his license through a different mechanism is not something we're contemplating here today. The board has chosen to limit itself in this proceeding to 2310. It has an accusation pending out there in which it can do or it can seek whatever it is seeking in that matter. But in this proceeding, under 2310, it must show a suspension or revocation. It cannot do that because the only document it is looking at is noted to be voluntary and expressly notes that suspension would be a separate action. And therefore, this is not a suspension in Massachusetts. It is not a revocation in Massachusetts. And California, under statute and under case law, which has been expressed only in respondent's argument and not in any counter argument, cannot interpret it any differently. For these reasons, we respectfully ask that the panel adopt ALJ Cox's decision, which was well-reasoned, legally analyzed, and 100% sound, and in compliance with the law that the board is obligated to follow. Thank you.
Thank you. Mr. Chambers, 5 minutes. The floor is yours.
Thank you. California has the authority to suspend respondent's license under Business and Professions Code 2310. Respondent claims that he wasn't suspended pursuant to the agreement he signed. So let's look at the agreement. Let's consider it a car. Let's consider it a red car. Respondent says it's not a red car. He says it's crimson or rose or cinnabar. But that doesn't change the fact that it has 4 tires, a steering wheel, an engine, a trunk, and transports people from point A to point B. And simply renaming the hue does not change the product's purpose and effect. So what is the purpose and effect of the voluntary agreement that he signed? It precludes him from practicing medicine anywhere in the United States. It's not a restriction. There was discussion earlier on about the legislature knowing the difference between restriction and suspension. Respondent is precluded from practicing medicine until Massachusetts decides differently. That's not a suspension, or that is a suspension. It's not a restriction. Restriction precludes a licensee from certain actions, not all actions, and certainly not a complete negation of one's ability to practice medicine nationwide, as happened here. We've heard mention that if the respondent were to breach his contract or agreement with Massachusetts, paragraph 8 says that Massachusetts can suspend his practice. What wasn't noted was the word before suspension, summary. If he's summarily suspended, he loses due process rights. Those rights are truncated. So if that's not in front of suspension, they then have to file an accusation, go through a very long process. They've put a caveat in there because they wanted to make sure there was teeth. There was argument earlier on that there were a number of patients who presented on behalf of the respondent at hearing, that he's not a danger to the public at present. But as you know, there's case law stating that the board does not need to show dangerous conduct that threatens the public's safety or actual harm to a client. That's at Hong, H-O-A-N-G versus California State Board of Pharmacy. That's 2014 case. It's at 230 Calap 4th at 448. The respondent can call this anything he wants, but the practical purpose and effect of that agreement is that he has been suspended. He cannot practice unless Massachusetts says he can. We're not asking Massachusetts for any permission. We're telling a respondent that even though he wants to work in California, and he stated so in his hearing at transcript page 77, lines 18 through 22, that because there was a suspension that we've proven up, the first part or the first element of 2310. And because it was provided to the practitioner's data bank, which we've proven up, that he cannot practice in California at this time. That's pursuant to Business Professions Code Section 2310. I thank you for your time.
All right, thank you very much. I appreciate your comments. Anything else, Dr. Thorpe, that you'd like to have for the record before I take us off?
No, Your Honor. Thank you very much.
All right, very good. In that case, Ms. Monares, I will take us off the record. And if you could give me an end time in pages, I would appreciate that.
Ending time 10:28. Give me a minute to get you the pages, please.
All right, very good. All right, while she's doing that, Dr. Thorpe, did you want to take a short recess before we go into closed session? I've been getting email reminders to join our 10 o'clock, even though it's 10:28. Well, what would you like to do?
I think it's, yeah, we will need to take a slight recess just as we make the transition anyway. So when we take a 5-minute recess and get everybody onto the closed session site and have a chance to get a drink or whatever needs you need to take care of.
All right, perfect. So people can sign off of this, and I'm just going to wait for Ms. Monares so I can get the page numbers, but I'll see the rest of you panel people in just a moment.
All right, thanks.
Dr. Thorpe, I will keep this meeting open for the members, the public attendees who would like to, know when we adjourn later on. So we will have to return back to this meeting. So for all the public attendees, it will stay open, but you will see the closed session splash screen in a few minutes while the members are in closed session. Thank you.
All right,
Thank you, Sean.
Sorry, everybody. I think my battery was so low that it wouldn't let me speak, and for some reason now I'm having trouble getting my camera to work. But anyway, Ms. Campoverde, would you be? So I think we need to just close the meeting by a motion to adjourn. Would you be willing to make the motion to adjourn?
Certainly. I move to adjourn our panel B meeting.
It's been moved, and I guess I can second it. I don't know. But I think we're the only ones here anyway, so
You're fine.
we'll just call the meeting adjourned. Thanks for your patience with me.